I'm Roger Citron, and I'm a professor at Touro University, Jacob D. Fuchsberg Law Center. This is a Touro Law Review podcast, and I'm delighted that today our guest is one of my faculty colleagues, Michael Lewyn, and we're going to be talking about property law, which Professor Lewyn teaches, and in particular, we'll be talking about zoning and the bar exam, which is the subject of an article that Professor Lewyn has written that is going to be published in a Florida State Law School journal, the Journal of Land Use and Environmental Law. And enough of my talking. Michael, please tell us a little bit about yourself before we jump into the topic du jour.
As Roger, as you said, I'm one of your colleagues. So even though I mostly teach first-year property, most of my scholarship is relevant to zoning and land use. Mostly I've been focused on a couple of issues relating to walkability and issues related to housing costs. But every so often I write about something that I haven't written about before because something just stirs my interest. And this article is an example. I was reading about the new bar exam, and I saw their content outline that the NCB publishes, and I noticed no mention of zoning, and naturally I was aghast.
Naturally. And your reaction is quite understandable. I guess we should probably start with the bar exam piece of our discussion, which is, where are we, where are law schools and NCBE, to the best of your knowledge, in terms of, modifying or changing the bar exam? Do you have a sense of that?
Yes, well, the NCB has issued this long timetable saying this is what we're going to do when. And I think probably the first testing under the new bar exam will be in 2026. And they're kind of going on two tracks. There's substantive changes, which is really what my article is more focused on. And then there's also skills change. That is to say, I think traditionally the bar exam has been hundreds of 200 multiple choice questions and some essays that are all about memorizing the law. And I think they're going to add some sort of skills component that, frankly, I don't really understand yet. Well, but I know it's out. But I know it's out there, waiting to get me. But
we'll steer clear of that for now,
yes,
and talk about the substantive piece, because the property course that you teach, I think it's fair to say it's tested. And it may be substantially tested on the bar exam, because under the current iteration, I believe it's an MBE subject, which means there's a certain number of multiple choice questions, and of course it could appear on the essay part as well.
Right. Yes. And I suspect that. I suspect that the current MBE subjects will still be significantly tested in some form. And in fact, they've issued content outlines, and the content outlines focus on the MBE subjects. So that tells me they're still going to be testing on the MBE subjects to the same extent that they will now. I think, but within those general categories, they're going to make some changes. They promise to focus on a narrower set of issues and to be a little less esoteric. And so my article is going to try an attempt to hold them to that promise. And so at any rate, they've published these outlines. It was sometime in 2022, and supposedly in 2024, they'll issue what's called test content specifications, which, as I understand, will be more detailed version of the outlines they've already published. And that hopefully they'll modify the outlines to some extent.
Okay, so that's helpful in orienting us. For those of us who can't recall, it's 2023 as we're sitting here talking. So what we have are the outlines, but we don't yet have the test content specifications as you described them.
Right, that's their technical phrase, and I'm not actually sure what those are. My suspicion is that they'll probably be like their current outlines, but more detailed. But that's sort of a guess. I'm not sure I really understand it.
Okay. Well, we'll figure it out next year, or we'll see what happens next year. And then for real property, uh, is zoning currently tested?
It is like, it's not, I don't, my impression is that it's tested, but not extensively. Of course, it's very hard to tell because I think, we don't have any actual, at least I don't have actual bar questions. All I have is what bar review companies put out, which may or may not reflect what's actually tested. So my impression is that there's like a smattering of zoning questions on the current bar. Like, in other words, so today, let's see, I think there's 30, I'm guessing 30 multiple choice questions for each of the topics. I mean, for each of the major subjects. Is that right?
Generally, yes.
So I would be surprised if they had more than 1 or 2 questions on zoning in a year. And then, of course, there's the essay portion. And once every few years, once in a while, they'll test on zoning in the essay portion. I'm not sure like what the most recent essay I have. I'm not sure we even have more essays after about 2018 or 19. So I don't really know how they've changed the essays over the past few years. But I do think that occasionally they'll test on zoning and also on the takings clause, which is, I think they view as constitutional law, but of course it's very intertwined with zoning as well.
And from your sense of what you have seen so far with respect to the changes coming to the bar exam, will zoning, as far as you know, with where we are, will it or will it not be tested? Is it not? Is it part of the subject outline?
Not all. It's not on the subject outline. Other than the takings clause, which is in the constitutional law subject outline, but I didn't see zoning on the outline at all, which of course was somewhat surprising.
And I'll take the bait. Why do you find that surprising?
Because I think first of all, zoning is a significant area of practice. So I would think if you're trying to prepare people for practice, it's probably more useful to expect people to have some knowledge of zoning than it is to dig ever deeper into the esoterica of one of the areas that is admittedly important. That is to say, I think about, let's say mortgages, for example. Okay, so they should know something, maybe they should know something about mortgages, but why should they know this much instead of this much? And then, of course, another reason I find it surprising is in terms of just the volume of litigation that zoning creates. It creates a lot more than a lot of things that are still on the bar exam. That is to say, the current outlines do slim down the bar exam to some extent in terms of involving less testing on obscure doctrines. So it seems like they might, for example, test the rule against perpetuities either less or not at all, which I think would be praiseworthy. And so I do think in terms of testing things that aren't important, they are at least somewhat moving in the right direction. Having said that, their content outline still contains lots of things that generate very few cases, certainly in comparison to some of the major zoning issues.
Those items that still are on the content outline, yet, a student graduating and practicing in the area, of what could be described as a real property practice. What are some of the things that you think fall into that area of, well, you might get tested on the bar exam, but you're unlikely to see it once you start practicing? What are some of those?
Well, I would say like some of the most, just thinking about some of the more esoteric future interest concepts. That is to say, you should certainly know if you're practicing in like wills or so forth, certainly it's really important to know, like, there's something called a life estate and something called a remainder, that maybe you might want to apportion ownership in some way other than giving somebody 100% forever ownership. But there are a lot of different types of remainders and executory interests and things like that that are very rarely litigated, for the simple reason, I think, that the reason there are many different types of interests relate to common law rules that have mostly been abolished. So, for example, I teach about something called a vested remainder and something called a contingent remainder. And the line between these is really complicated. So in 1920, it was actually pretty important to know whether a remainder is vested or contingent, because there are all these rules that would sometimes make contingent remainders invalid that didn't apply to vested remainders. But today, those rules have all been abolished. So really, there's no practical reason, other than maybe occasionally looking at a document drafted in 1920, why it's important to know the difference between a vested remainder and a contingent remainder. So that's kind of one example of a obscure doctrine that really, again, and also in terms of like the number of cases that come up, it's very rarely litigated.
Yeah, yeah. I guess I want to first of all, I want to say that if I ever knew the difference, it would have evaporated shortly after, the end of July 1992 when I took the bar exam. But why do you think? I know from your article, one reason I think you suggest that there may be this. Oh well, zoning is local, and so that's, so forgive the expression, contingent in the sense of, well, it really depends upon what jurisdiction you're in, so it's really not an ideal subject for the bar exam. Do you, I guess, do you feel like that's part of the reason why zoning isn't on the list, and do you have any thoughts about the validity of that reasoning?
So my short answer is yes, but. And so what I mean by that is I actually do think that's a legitimate concern. I actually really thought, okay, well, this is what I want to write about in my article, because zoning is harder to test in a lot of issues. And so I begin with an assumption that of what the bar should test on should be areas, normally the bar should be testing on areas where there's a national majority rule to test on, where, in other words, if people are supposed to know the law, people should know what the law is. Although, frankly, I'm not sure to what extent the bar exam even follows that. I mean, I've seen some bar review companies' questions that seem to say, oh, follow this rule instead of that rule. And you get the sense that maybe the bar exam just expects you to know multiple rules, which is obviously maybe the subject for another article. But let's assume, for the sake of argument, that the bar exam is going to clean that up, that they're just not going to focus on areas where there's really nothing resembling a national consensus, right? So I guess then the question becomes, is there any zoning issues that involve something like a national consensus? And I think there are. I think even though zoning is often a matter of local law rather than state law, which certainly implies that maybe it'll be harder to find out a national majority rule because you're not counting the states as you would be for something that has to say, when you have a rule that's created by state legislatures, it's presumable it should be pretty easy to find out the national majority rule, because you can count how many states are on one side and how many states on the other, right? Zoning is often local, so you can't really say that. But even so, there are, and so certainly you can't, because of that, I'm sure you probably can't test on zoning to the same extent you could test on some other issues. But still, there's enough of a national common law on zoning, if you look at treatises, for example, that I think there are at least a few basic things that you can test on that everybody should know. So, for example, every young lawyer should perhaps know, at least as much as other property issues. So, for example, one rule governing both the initial adoption of a zoning code and zoning changes is substantive due process. The idea that zoning changes are valid as long as they're supported by a rational basis. So I think generally that's something that is so widespread and so frequently described in treatises that I don't, and certainly in case books, that I don't think it's unreasonable to expect students to young lawyers to know, well, most zoning decisions are valid if they're supported by a rational basis.
And just to be clear, because I know that I think the first couple of questions in the law review article pick up on this point. And this is where, you know, it really sounds like con law. That is because of the standard of review that's being applied to, you know, to a government action or regulation. But this isn't picked up in con law, to the best of your knowledge. Is that correct? I mean, in other words,
I think certainly substantive due process generally is part of con law. I'm not sure to what extent it's like, actually now I'm just looking at, see if I can find the con law outline. Let's see, due process, substantive due process. Let's see, substantive due process and privacy, other individual rights. Yeah, it doesn't seem to be substantive. It seems like substantive due process is mostly in the context of things like abortion. You know, it's kind of the right to privacy. And also, of course, there's although there's equal protection, but and there is a the constitutional law outline does mention the kind of general rational basis test applying to equal protection, but that's much broader and much vaguer. So, I mean, I think it's important for people to see, well, this is not just even though, yes, it applies in theory to every government regulation, it's really more likely to be applied to zoning than many other things.
Yeah. No, that is certainly one area. It seems that I really like your expression. There's kind of like in effect, a common law, a consensus on the common law as to what the rule is or rules are. What other types of questions or topics do you think would be fair game if you were going to, you know, that are zoning related that you could fairly test on for the bar exam?
I would say things that kind of the major areas of putting flexibility in zoning. And so I mean by that, not just rezoning, but I think variances is probably one of the most common. So people should know what I think it's reasonable to expect people to know what a variance is and how different it is from rezoning. So actually, let me explain what a variance is, first of all, because I'm realizing that at this point, if there's an audience, I'm probably losing it. A variance is essentially a special exception to the zoning code just for one landowner. And so it usually happens where there's some sort of unusual hardship created by the zoning code that maybe applies specifically to this one owner. So the classic example is a case where somebody has a building lot, and that lot is 5,000 square feet, but the zoning code says there has to be an 8,000 minimum square foot lot in this area or in this block. So that basically means that it's not possible to comply with the zoning code and build anything at all. So that's a situation where it's obviously insane to have land just be completely useless because of the zoning code. And so what the law typically does is say, well, in this situation, because of your unusual situation, we'll grant an exception to the zoning code. So I think that's seems commonly litigated enough to be noteworthy. And more important, also, I do think this is an area where there's at least something of a common law. That is to say, even though there are even though different states have sort of different balancing tests, I think generally there is, as a general proposition, I think it's fair to say that courts balance the hardship to the landowner from not getting a variance against whatever harm a variance would cause. So maybe that broad general rule is something you could test on in a bar exam question.
I sort of, to the extent that we haven't discussed it already, and perhaps we've covered it, do do you have anything more to say on with the bar exam, you know, why it, you know, seems to undertest zoning
Uh-huh.
and why it may continue to test on areas that, well, actually, I'll stop with the
Uh-huh.
first part of the question, right? Which is there anything more than what we've talked about that explains sort of the undertesting of zoning or the reluctance to test on zoning?
Well, I think there's time maybe I think one thing is might be just thinking about zoning is an area I think that's over the decades become more complicated and more strict in most places. And really has had probably more of a negative impact on housing supply. And I think the bar exam typically it seems like it's a very conservative institution. My sense is that the bar exam, maybe not so much in criminal procedure and constitutional law, because those areas Supreme Court precedent forces it to make actual changes. I look at the bar exam, the bar outlines I have for Barbary, it looks like they're sort of stuck in about 1970. That the bar
Uh-huh.
exam just refuses to change with the law to some extent. Because I'm guessing there are bureaucrats out there who are doing this work at NCBE, and they probably have a lot of better things to do with their time than worry about do we need to change this question or that question to keep up with changes in the law. And so I think it's just hard to change. And probably in 1970 there was just less zoning law out there to test on.
Yeah, and I just to be, to reiterate, this is right a, an interpretation by you. That is to say,
Which is a fancy
this
way
is
of saying a guess.
yes. I was going to use the more formal term of speculative or speculation, but I
Yes.
think that also is synonymous with guess here. Um, and yeah, I wonder like how that sort of may intersect with or really is driven by, well, there's lots of different jurisdictions. And so even, to the extent that law faculty are, involved
Mhm.
in reviewing or contributing to, you know, the subjects, the questions, and so on. Um, but there may be a sense of, well, there
Mhm.
really isn't sufficient uniformity
Mhm.
to
Yeah.
to update or to
Right.
advance where we are in the
Right. And
outline
not
or
only
change the
and I,
outline.
yeah. I mean, I would think, and I do think this is a problem for all of property law. It's worse for zoning because zoning is local rather than state. But I mean, I look at these Barbary outlines, and often I think maybe I should teach this. And then I do a Westlaw search, and I realize the result, the rule that Barbary says is the law, which I assume they got from somewhere, as I can't find a case that supports this rule. I wonder. It's I just think to create, figure out what's the rule we want to test on is really a huge problem for the common law subjects generally.
Mhm.
I mean, I haven't taught contracts. I've never taught contracts, and I haven't taught torts in a very long time. So I can't say whether it's worse for contracts or torts than it is for property. But even for the subjects that are a matter of state law, figuring out a national majority rule is very hard. Seems sometimes to be very hard.
Yeah, I mean, this is purely sort of anecdotal. I know that a number of years ago, when New York went to the uniform bar exam, at least one of our former colleagues who taught contracts was of the view of, oh, you know, the shift to from a New York bar exam to a uniform bar exam won't make a meaningful difference because the New York generally the New York rules comport with the uniform rules or the model rules. Um, and that isn't, it's funny, that isn't exactly on point to what you're saying, but that's what I think about when I think about, oh, contracts as a common law subject. Can you
Uh-huh.
test it under the UBE?
Yeah.
I think this person's view was, oh, it'll actually be a very easy transition. In other words, how New York tested is almost virtually certain.
Well, I would imagine, the UCC in contracts probably creates a degree of uniformity that's not present in property. I mean, we do have a restatement in property, but I really don't think that. I don't get this. My general sense is states don't really care about the restatement of property. That there are a lot of areas where the restatement is new enough to be like, the restatement is often 20 or 30 years ahead of its time. It's like the other extreme from the bar exam. The bar exam is 30 or 40, 30 years behind the times. The restatement is 30 years ahead of the times.
Yeah, I can't speak to this in the area that I know, of course, which is civil procedure, because of course we have rules and Supreme Court case law, especially Supreme Court case law with respect to jurisdiction, which is heavily tested. But I will say that in my experience, or my impression is, I do think that the contracts restatement, I guess it's the restatement second, I believe, is the current edition. It's treated with a reverence and a respect that I'm not sure other restatements enjoy.
There's a statement that actually restates the law. That's interesting. I'll just say that's interesting. I was about to use the word communism, but that might not be fair. It's very strange to me.
You also touched on, when you were talking about, taking a look at the outlines and thinking, is this something I should do in class? I think the last thing I wanted to ask was, property, like civil procedure, is a 2-semester course at Toro. How do you, in going through the 2 semesters and the different topics, I kind of want to ask the question as broadly as possible, which is, how does the bar exam influence how you teach, what you teach, and how you teach property in your 2 semesters?
I think so, and I actually think it probably influences less than zone. The areas that are least tested are probably the areas where it has the least sway. Like, in other words, I teach probably more intellectual property than other people, because I feel like it's important for people to know some of the have some cultural literacy, to know, okay, should I take this upper class elective? Should I look for jobs in this subject? And similarly, zoning, the bar exam actually probably has less sway, because to me, that I think this is an important area of practice. And if there was no bar exam, I would probably teach it a little even more, but I would still probably teach it more I probably add more local bar exam content than I think other professors would. But it probably has the most impact on the areas. Well, one area where it's a ton of impact is, of course, estates and future interests, because you have so many law rules that are just as I told you, are obsolete, and that I teach them because of the bar. I mean, basically that part of the course, without the bar exam, it would be maybe 1 or 2 days instead of 3 weeks.
Okay. Do you feel like, 6 credits, that's a lot of time.
6 are a lot of time, yes.
You don't leave I was going to say, you don't leave anything on the table one way or the other. In other words, you have enough time to meaningfully cover the bar exam subjects and to meaningfully cover the other subjects. Let me
put it this way. I feel like I have enough time to cover the basics of everything. I don't have enough time to cover every possible bar exam, every possible rule in here, because that would take like 30 credits. In fact, and let me add, this is the one area where I want to praise the bar exam, where I think, if anything, it doesn't go far enough, except for zoning. That is to say, the bar exam, and you can tell by looking at the MEE essays and their model answers, the bar exam, the bar exam as currently configured really just has an insane level of detail. There's so much people have to know that's far beyond what you would find in in any case book. I mean, to me, frankly, the bar exam should be the bar exam idea. If you had my ideal bar exam, say for property, it would be roughly, in terms of its depth, it would probably be roughly similar to the leading case book. And if it's not in the leading case book, it wouldn't be on the bar. That's the level of knowledge that I think it's reasonable to expect young lawyers to have. And so, and the bar exam goes far deeper, of course, than this. And so I try to some extent to accommodate that. I mean, I think, frankly, in real estate transactions, which I feel it seems like it's very, very heavily tested, I try to add more than the bar exam does. And I feel like I mostly try to add a little more every year because it's such an overwhelming topic. So that's one area where I think one area where the bar exam does shape me is shape my work. I try to add where I feel like the casebook's not covering let me rephrase this, where I feel like the gap between what the casebook covers and the bar exam covers is most overwhelming. I at least try to add some extra material. And I think that's especially true for real estate transactions, because I think casebook authors seem to think everybody's going to take real estate transactions.
Uh-huh. Do you do that just by lecture? Do you give out any sort of supplemental materials?
I basically add cases. Basically what I look for is, well, is there a case that teaches bar concept X that is not insanely complicated? And often, like I fail. Often I'm like, it would be good to teach this, but I can't find a good case. So I try mostly to, when I'm doing this, I try to add, more bite-sized cases.
Uh-huh.
But I feel like a case method, by giving you a real life example, hopefully it makes it easier for students to understand. And also I think to test on, something that's I just like talked about for 5 minutes without giving them a case seems like not fair play.
Uh-huh. Well, let me ask this. I think, I know we corresponded before our discussion today, and I think we've covered the questions. Anything we've left out that you think would be either from your article or from our discussion that is useful to think about in connection with real property, zoning, and the bar exam?
I'm sure I'll have the answer 10 minutes after we log off, but not now, because you always think of the one. Well, if you're me, you always think of the best answer, the best riposte 10 minutes after the moment has passed.
I had a boss at the Department of Justice who his first job at the Department of Justice was working in civil appellate. And he would go around the country and argue different, cases in different circuits. And I know he once said to an expert witness who was testifying in a case that we were working on, he was talking about, what's it like to testify? And he said the analogy for him was, of course, arguing these cases. And he said, you argue a case 3 times. The first time, practice. The second time, when you actually argue it. And the next day in the shower, when you think of what you should have said. So in oral argument, as in teaching, I don't think we'll have the camera on, but I can't wait to hear your answer to the question the next time I see you. So if that's it.
That's it.
All right. I thank you for your time. And I know I'll see you around school. Thank you.
Yes. Okay, great.